Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are addressing inquiries, questions as to when in the matter styled as Goncalves et al. Versus Washington State University is trial scheduled for. If you look at the complaint that the plaintiffs filed back on January 7th, 2026, you will see that there is a demand for a trial in this action by jury. There is no jury trial as of yet that appears on the public docket in this case. And we can learn more why no trial has been scheduled as of yet by looking at what Judge Evanson ruled back on February 5th, 2026. This is document number 15. It is notice to the parties. The court acknowledges the requirements of FRCP 16b2, but finds good cause to defer entry of a case schedule pending its ruling on defendant's motion to change venue, docket number 8. FRCP, as noted here, refers to Federal Rule Civil Procedure 16b2, and that mandates that a scheduling order, an initial scheduling order, is to appear in federal cases. That would include deadlines for key events in the case, one of which is when discovery cutoff is. When an FRCP 16b2 schedule comes out, signed by the judge, you will see a notification that discovery must be completed by whatever date is listed in that scheduling order. So in other words, all of the evidence that the defendant may seek from the plaintiff might seek from the defendant through the discovery tools that are available in federal court, such as depositions of the parties, such as requests for admissions, interrogatories, requests for production of documents, and also sometimes the parties will serve non-party discovery. They seek to take the deposition of someone else, a non-party. Under FRCP 16b2, there may also be other events such as the date for the trial that might be listed in that initial scheduling order. Bottom line is no scheduling order is going to be entered until after the court resolves the motion to transfer venue that WSU filed back on January 30th, 2026, which makes good sense because if the court rules that yes, transfer of venue should happen for the reasons set forth in the defense's motion, which, by the way, the plaintiffs are very aggressively opposing. They want the case to stay here. Then any work going into a scheduling order would be for naught because the case will be closed in the Western District, transferred to the Eastern District in a court closer to Pullman, which is what the defense is asking for. And then a new case opened up, a new judge assigned. That judge would then set forth this Federal Civ Pro 16b2 scheduling order, which might include the trial date. If, however, the judge rules in favor of plaintiff and says, no, this case is staying here, then you can expect to see the scheduling order coming out thereafter with potentially a trial date set forth therein. As of right now, there is no court order on the motion to transfer venue. We just did some content over this past weekend that went over the status of the motion to transfer venue, which we've included a link in the description to this podcast episode if you would like to listen to it. Until next time, this is Kathy. Thank you very much for joining us here today.